Good afternoon. It is my pleasure to warmly welcome all of you to this very special session where we will be having the inaugural talk of the Exploring Central Asia talk series organized by the Tillotoma Foundation. Central Asia has been a crucial focus area of the Tillotoma Foundation, manifested through a large number of initiatives in this area. The inaugural talk will be on the topic International Law and Regional Contexts in Central Asia. The talk will be delivered by eminent legal expert from Central Asia, Dr. Sergey Sayapin, Associate Professor and Associate Dean, School of Law, Kimmep University. The session will be chaired by Dr. Kamakshi Wason, Chief Operating Officer and Director of Academic Programs, Tillotoma Foundation. Thank you so much for being here. Let me now request Dr. Wasan to kindly deliver the opening remarks and begin with the session. Thank you.
Hello, everyone. Thank you, Ms. Acharya. I welcome you all to the special lecture session on international law and regional context in Central Asia as the inaugural talk of the Exploring Central Asia Talk series organized by the Tillotoma Foundation. I am Kamakshi Wason, Chief Operating Officer and Director of Academic Programs, Tillotoma Foundation. Tillotoma Foundation works globally in the areas of international relations, diplomacy, area studies, gender, environmental, scientific, strategic, and defense policy. Central Asia remains an important focus area of the Foundation. We have a dedicated research center on the region at the Tillotoma Foundation. Over the years, the Foundation has actively cooperated with and worked with institutions, senior experts, and diplomats from Central Asia. The Foundation has also organized several Track 2 diplomatic conclaves and major international seminars on Central Asia. Today, the topic for the special lecture is international law and the specific regional context in Central Asia. I'm sure we will have in-depth, erudite discussion on the subject. I'm pleased to welcome our distinguished speaker for today, Dr. Sergey Sayapin, noted legal expert on Central Asia and the post-Soviet space, Associate Professor of Law and Associate Dean at the School of Law, Kazakhstan Institute of Management, Economics, and Strategic Research University. He joins us from Almaty, Kazakhstan. Thank you, Dr. Sayapin, for being here today to speak on this very relevant and interesting topic. I would now like to request Dr. Sayapin to start with his address. Over to you, Dr. Sayapin.
Thank you very much, dear colleagues. I am very pleased to be with you today and to be able to deliver the talk. With your permission, I will speak for about 30 minutes, and then I'll be happy to take your questions specifically on international law in Central Asia or on more general topics of international law. And here you see an outline of my lecture for today. I would like to start by giving you a background about the place of international law in the domestic legal systems in Central Asia. Then I will say a few words about the role of international law for the international legal profession in the region. And then we'll discuss a few notable examples concerning Central Asian practices of international law, ranging from international peace and security through international environmental law, human rights, and international investment arbitration. And then I will offer a few conclusions at the end. Well, what do we mean by Central Asia? Central Asia is, in geographical and political terms, a region of 5 post-Soviet nations, that is Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan. All of these nations are very diverse in geographical, historical, cultural, and political terms, but in legal terms, they have some common heritage. Historically, these nations have been under the influence of such legal traditions as Islamic law, but then in the 20th century, the influence of Soviet law, that is continental law, has been significant, and therefore all Central Asian nations are now secular states with continental legal systems. And international law has some prominent place in the legislation of all Central Asian countries. Let's start with Kazakhstan. As you see, the Constitution of Kazakhstan provides that international agreements and other commitments of the Republic are part of the functioning law in the Republic of Kazakhstan. The Constitution further provides that international agreements ratified by the Republic of Kazakhstan have primacy over its laws. So this is to say that not all international agreements to which Kazakhstan is a party have primacy over its laws, but those which have been ratified, they do. The language describing relationship between international law and domestic law varies from one Central Asian country to another. For example, the Constitution of Kyrgyzstan stipulates that generally recognized principles and norms of international law are an integral part of the legal system of the Kyrgyz Republic. That is unlike the Constitution of Kazakhstan, which refers directly to international agreements ratified by the state. The Constitution of Kyrgyzstan speaks more broadly of generally recognized principles and norms. And the same is true for the Constitution of Turkmenistan, whereby Turkmenistan recognizes the priority of universally recognized norms of international law. In turn, the Constitution of Tajikistan is somewhat more positivist in its attitude towards international law. The Constitution of Tajikistan stipulates specifically that international legal acts, that is, written documents of international law recognized by Tajikistan, are an integral part of its legal system. And last but not least, the Constitution of Uzbekistan contains a few provisions concerning the relationship between international and domestic law. On the one hand, the preamble stipulates that the priority of the generally recognized norms of international law is recognized. And on the other hand, there is Article 17 in the Constitution dealing specifically with the role of international law in international relations and foreign policy. So this article says that the Republic of Uzbekistan is a full-fledged subject of international relations, that its foreign policy is based on some fundamental principles of international law and other universally recognized principles and norms of international law. Very importantly, the Republic has the right to join and leave various international institutions. So, in constitutional terms, as we have just seen, international law has some place in the domestic legal systems. Yet, there are rules pertaining to international law also in other instruments of domestic law, such as Kazakhstan's legal policy for 10 years, from 2020 until 2030. So, the legal policy concept provides that international law has a role to play for the purpose of further integration into the world economy, for the purpose of promotion and protection of state interests in international organizations and multilateral economic integration associations. However, it is notable that no mention is made of a direct application of treaties in the domestic legal system in accordance with the law on legal acts. So this is to say that the legal policy concept takes a rather narrow approach towards international law. It should also be mentioned that the legal policy concept speaks of the national interests of the state, of state interests, and makes no mention of the role international law can play for the welfare of the individual. And notably, during a parliamentary debate on the draft legal policy concept, before it was adopted, it was proposed to consider some restrictions on the application of the norms of international agreements in Kazakhstan. This was probably related to the fact that Kazakhstan had lost previously in significant international investment arbitrations, and as a result, there were proposals to limit the application of international law. Luckily, this has not happened in the final text of the legal policy concept. Now let me proceed to the role of the international law for the international legal profession. At this time in Central Asia, there are 3 generations of international lawyers, and it is significant to know this in order to understand the academic dynamics in the field. The first generation are academics, senior academics, who were educated and trained as international lawyers in the Soviet Union, and therefore, in the language of our Estonian colleague, Professor Malkso, they feel tied together by a common language, that is Russian, history and geographical space in the former USSR. Most senior international lawyers in Central Asia do not speak English or other foreign languages, and therefore they tend to work closely together with colleagues in Russia, in the larger post-Soviet space, and do most of their academic work in those professional circumstances. On the other hand, the second and third generations of international lawyers, this being said, I consider myself belonging to the second generation, because I was already trained after 1991, after the collapse of the Soviet Union, and the third generation is the generation of my students. So these 2 generations are already well versed in various languages. We use and read both post-Soviet and other doctrinal sources on international law, and some of my peers are now working for international, intergovernmental and non-governmental organizations, consultancies, private law practices, and therefore our professional philosophy is broader than being limited only to the Russian-speaking post-Soviet space. Let me show you a few notable publications by Central Asian international law scholars, such as these books on regional integration in the post-Soviet area, on international trade law and international economic law, or else on international trade law and the law of the World Trade Organization, on international criminal law, and international law and security. Very importantly, last year we started publishing a Central Asian yearbook of international law and international relations, and we hope to be able to develop this publication. So, having said that, there are a few issues which are fairly important and deserve to be mentioned in the context of the international legal profession. Just now, I've shown you some publications produced by authors with origins in Central Asia. However, some of those authors are still based in Central Asia and others are elsewhere. And the question is whether those authors who are outside Central Asia still consider themselves Central Asian authors, or do they already consider themselves as, for example, South Korean or British or authors with Central Asian origins? And I think this question has some importance. Also, it's important that these academic successes depend to a large extent on the enthusiasm and ambitions of individual authors rather than on demand or support from the state. These important books have been published and accomplished not because there was a clear demand from the respective Central Asian nations, but because the individual authors had the potential and ambitions to do that. In Central Asia, there are only two international law associations, in Kazakhstan and in Uzbekistan. In the other three Central Asian countries, there are no international law associations, and even those two do not work regularly. And it would be great if both associations could accomplish more work more extensively and more regularly. And unfortunately, the practice of international law is now largely detached from its scholarship, in the sense that ministries of foreign affairs and other organs responsible for international relations, of course, do very important work in the area of international law, as I'll show you in just a few moments. But this work is not regularly supported by academic expertise, and it would be very useful if academics had a larger role to play in the drafting of international agreements and could support more regularly the practical efforts of the Central Asian nations. And now let's move to the aspects of practice. The Central Asian states have produced quite a few important accomplishments in various areas of international law. For example, in the area of international peace and security, it is notable that Turkmenistan is the only Central Asian nation which is permanently neutral. This is written into the constitution of Turkmenistan, and the constitution of Turkmenistan is, by the way, the only Central Asian constitution which explicitly mentions the United Nations, in the context that the United Nations has recognized the permanent neutrality of Turkmenistan. And as you see, the permanent neutrality is the basis of Turkmenistan's domestic and foreign policy. In turn, Central Asia is one of the world's nuclear weapon-free zones. A relevant treaty was signed in 2008 and entered into force in 2009. This is very important, since the position of the Central Asian nations against nuclear weapons is firm and very, very principled. On the slide, you see on the left a painting by a famous Kazakhstani artist, Karibek Kuyukov, who is depicted on the picture on the right. He was born in the Soviet Union near a testing site for nuclear weapons in the territory of Kazakhstan. And as you see, unfortunately, he was born without arms. And he dedicated his artistic ability to spreading the message against nuclear weapons, and now he's one of the best known champions of Kazakhstan in the international anti-nuclear weapon movement. In 2010, Kazakhstan was the first Central Asian state, and more largely the first post-Soviet state, to chair the Organization for Security and Cooperation in Europe. That was an important occasion for Kazakhstan to disseminate international law messages of concern to the international community. As far as Uzbekistan is concerned, it's promulgated 11 years ago its concept on the foreign political activity, which deals with a few important issues of international law. In the same year, Uzbekistan suspended its membership in the Collective Security Treaty Organization. As you may know, this is a regional security organization composed of several post-Soviet nations. And Uzbekistan pays close attention to the security situation in the neighboring Afghanistan, and it hosted a few high-level conferences on regional security and specifically on security in Afghanistan. All Central Asian nations were admitted to the United Nations on the 2nd of March 1992, and they were able to promote through the medium of the UN a few important messages related to international law. For example, Uzbekistan had 5 locations placed on UNESCO's World Heritage List, such as the Old City in Khiva, the center of Bukhara, Shahrizabs, the historical center of Samarkand, and Western Tian Shan. Uzbekistan also placed 8 of its cultural traditions on UNESCO's Register of Intangible Cultural Heritage. These include the cultural space of Boysun district, the traditional singing, Katta Ashula, the art of improvised joking, Askiya, the culture and tradition of cooking plov, probably the most famous Uzbek food, safeguarding the traditional technologies of making atlas and adras, the traditional Horazm dance Lazgi, the art of painting, of miniature painting, and Bakshi art, the art of playing string musical instruments. So in that sense, the United Nations was very, very useful for Uzbekistan to promote its cultural heritage. Likewise, universal international organizations were important in peacemaking after the civil war in Tajikistan, which lasted for 5 years in the 1990s. As already mentioned, in 1995, Turkmenistan had its permanent neutrality recognized by the United Nations General Assembly, and in 2007, the UN Regional Center for Preventive Diplomacy for Central Asia was established in the capital of Turkmenistan, in Ashgabat. In addition to chairing the OSCE in 2010, Kazakhstan was a non-permanent member of the United Nations Security Council in 2017 and 2018. And Central Asian states were active in a few regional organizations, such as the Commonwealth of Independent States, the Collective Security Treaty Organization, the Shanghai Cooperation Organization, and the Eurasian Economic Union. Now there are debates ongoing about whether or not a Central Asian Union should be established as a form of a closer regional integration in Central Asia that would make cooperation between the 5 Central Asian states even closer and more fruitful. But that is a question for the future. Speaking about international environmental law, the big catastrophe of Central Asia is the Aral Sea. The Aral Sea was once the 4th largest lake in the world, and you're seeing on the slide what happened to it in the past decades. In 1970, it was still full. In 1990, it became visibly smaller, and as of 2014, only about 10% of the original size of the lake remained. This was due to predatory irrigation policies of the Soviet government, whereby water was taken from the 2 rivers feeding the Aral Sea for the irrigation of cotton, and at some point the situation reached a point of no return, and this is the way the former Aral Sea looks now. Of course, this disaster had an effect on the environment, but also on the economy. in particular of Uzbekistan and Kazakhstan, because these two nations were sharing the Aral Sea, but also on the health and well-being of the populations of the other Central Asian states, because it had an effect on the climate of the whole Central Asia. Regarding international human rights law, the Central Asian states have all ratified the main international human rights instruments and are doing some work to improve the human rights practices. However, quite a few issues are still remaining on the agenda, most notably such issues as the independence of trade unions, the freedom of religion. Domestic violence is unfortunately widespread in the region. The freedom of assembly raises some concerns. The LGBTQ plus rights, the rights of refugees sometimes are debated. The freedom of the press is on the radar of international human rights law monitors, and other issues still require attention. As far as international humanitarian law is concerned, you will remember I said a few minutes ago that in the 1990s, there was a civil war in Tajikistan, and this was when the International Committee of the Red Cross arrived in Central Asia in order to render protection and assistance to the victims of that war. And the ICRC regional delegation has been located in the capital of Uzbekistan, in Tashkent, ever since. And the ICRC in Central Asia now does work in various areas, such as the implementation of international humanitarian law in the domestic legislation, running educational programs for school children and universities, supporting the ministries of defense and interior in the domestication of international humanitarian and human rights law, and cooperation with the Red Crescent societies in all 5 Central Asian states. As far as international and transnational criminal law is concerned, quite some work has been done here as well. That is, the criminal codes of all Central Asian states penalize all core crimes under international law, except crimes against humanity. These are penalized only in Kyrgyzstan. And some transnational crimes are penalized as well. The general part, that is, the general principles of international criminal law, have been implemented in the domestic criminal codes quite well. Fortunately enough, there is no case law so far involving crimes under international law in Central Asia. And among all the Central Asian nations, Tajikistan is the only state party to the Rome Statute of the International Criminal Court, ICC. This is to say that despite that the Rome Statute was ratified only by Tajikistan, all Central Asian nations did quite some important work to implement international criminal law, even irrespective of the International Criminal Court. So, in other words, the ratification of the Rome Statute is immaterial for the implementation of international criminal law in Central Asia. And just as a side note, very helpful in the implementation of international criminal law was a textbook written by Professor Gerhard Werle and translated by your obedient servant into Russian and published in 2011. Last but not least, international investment arbitration is an important topic. All states of the region except Turkmenistan are parties to the 1958 New York Convention. the Exit Convention has been ratified by Kazakhstan, Turkmenistan, and Uzbekistan. Kyrgyzstan signed the convention, but has not yet ratified it, and Tajikistan is not a signatory state. In 2015, Kazakhstan adopted a constitutional law on the Astana International Financial Center with a view to providing high quality financial and legal services to international investors. However, some lawyers in Kazakhstan have criticized the alleged incompatibility of the Astana International Financial Center with the Constitution of Kazakhstan. Under the Constitution and the applicable law, the International Financial Center has a special legal status. From the perspective of the critics, this special legal status is not compatible with the constitutional foundations of a unitary state. So, be it as it may, the center is there. It is a reality, and in 2018, the president of Uzbekistan signed a decree establishing a similar center in Tashkent, in the capital of Uzbekistan. So, which means that the model is getting popular in the region. And as I mentioned earlier, in 2013, an important award was rendered in the case of Stati and others versus Kazakhstan, and this was the arbitral award, which probably moved some decision makers in Kazakhstan to suggest limiting the role of international law in the domestic legal system, as we discussed earlier in this presentation. And dear colleagues, let me conclude by suggesting a few observations and recommendations. So, as we saw, all Central Asian states have enacted foreign policy concepts which provide for a place to international law in the domestic legal and political systems. This is a praiseworthy development. This is good. However, a few more measures will be in order, will be useful. For example, I think that regular expert dialogue between international law scholars and the authorities in the Central Asian states is required. This will improve the quality of rulemaking and applying the rules of international law on the one hand, and this will make the scholars' academic work better tied to real-world developments. In other words, such cooperation will enrich the theory and practice of international law alike. I think it will be useful to organize regular in-service training on international law for experts working in various state organs, national human rights institutions, and especially for judges and law enforcement officials, so that they get used to applying relevant instruments of international law in their practice. I also believe that teaching international law at Central Asian universities should more closely relate to regional challenges. Of course, we are used to using some of the world's best textbooks of international law, but the studying of international law will be more interesting and useful if it's based on local challenges, such as those which I mentioned earlier in my presentation, because thus it will be possible to show how international law responds to and helps resolve those regional issues. And last but not least, Central Asian international law scholars should participate more actively in the international academic dialogue, join international law associations in Asia, in Europe, North America and elsewhere in order to be able to present their points of view, their perspectives, and also to learn from colleagues, because international law is well, because universal international law is there for everyone. At this, dear colleagues, let me conclude. Let me thank you very, very much for your attention, and I will try to answer your questions. Thank you very much.
Thank you, Dr. Sayapin, for your interpretive address on this very pertinent topic. Now we'll take few questions. Also, if anybody has any questions, please feel free to write them in the chat box and we'll read it out for you to our speaker. So I have a question to begin with. Do you think can international law limit the territorial sovereignty of state?
Yeah, this is a fundamental question. International law is by definition a law for sovereign states, which means that sovereignty has domestic and international dimensions. It's the domestic dimension of sovereignty means that a state is supreme and leading in the domestic policy on its territory and with respect to its nationals. And the international dimension of sovereignty means that a state is independent in its foreign policy. So to that extent, international law is both an opportunity and a constraint. It is an opportunity because it enables all states, large and small, developed and developing, to do what they can to cooperate with others and to work with others in order to respond jointly to whatever challenges they have. But it is also a constraint in that states feel that they are not allowed to do whatever they want. So, in other words, states create the rules of international law in order to facilitate their cooperation in various areas, but at the same time, they place limits on their own behavior in the framework of that cooperation, so that the behavior of states becomes predictable, more consistent, and in that sense, more reliable. So, to sum up, as any regulator, international law creates opportunities, but also places limitations on the behavior of actors, and it is fine because any law does the same.
Thank you, Dr. Sayapin. So I have another question. Is modern customary international law really law as traditionally understood? Should foreign law ever be used by a judge to support decisions?
Thank you. Customary international law is one of the main sources of international law. And historically, custom was even the most important source of international law. If we look, for instance, at the 1961 Vienna Convention on Diplomatic Relations, we'll see that the convention was adopted in the middle of the 20th century. But before that, diplomatic relations were carried out on the basis of international custom. And the convention was a codification of customary rules of international law, which have been in place for centuries and even millennia. So customary international law still has some place in the regulation of international relations, although international treaty law is superseding it, and increasingly so since the 20th century, because states are now preferring to conclude treaties on various aspects, and to the extent that there is a treaty regulating an aspect or an issue. So it sort of supersedes the customary international law applicable to the same aspect or issue. Yet international custom does retain some role, not least because not all treaties are universal. For example, some human rights treaties have not been adhered to by all states in the world. And so those states which have not yet ratified a specific human rights treaty, they remain bound by rules of customary international law regulating that subject. With your permission, I will take the first question from the chat. Do you think international law should be applicable to the non-state actors too? Well, it is already applicable to some non-state actors, or more specifically, some rules of international law are increasingly applicable to non-state actors. Examples: international humanitarian law, that is the law of armed conflicts, is by definition applicable to some non-state actors, in particular the non-state armed groups, because it is understood that in non-international armed conflicts, states use military force against non-state actors, or else such non-state actors fight against one another. And there are limited rules of humanitarian law which apply in non-international armed conflicts. In comparison with the rules applicable to international armed conflicts, so in non-international armed conflicts, there are just a few rules, because states do not want to, and rightly so, to compromise their sovereignty. They do not want to regard themselves on the same footing with those non-state armed groups, and therefore do not agree to give to the non-state armed groups the same amount of rights and obligations under international law as they have themselves. So rules of humanitarian law applicable to non-state actors in non-international armed conflicts are just a few. They are mostly humanitarian in nature, but it already shows that the character of international law is changing. This change in the character of international law is even more visible in international investment law, whereby states conclude investment agreements with economic actors, essentially, with multinational corporations, with transnational corporations, for the purpose of protecting investments made by those essentially economic actors in the territories of sovereign states. The fact that under such investment agreements, state and non-state economic entities have mutual rights and obligations does mean that the character and nature of international law is changing, and states are recognizing influential economic actors as subjects of international investment law, and acknowledge that those subjects do and should have ways to protect their rights through the judiciary or through arbitration. So to sum up on this, yes, international law is becoming different. In the past centuries, it was exclusively a law for states. Now it is increasingly also a law for non-state actors, at least in selected areas.
Thank you, Dr. Sayapin. Sorry due to some technical difficulty, I couldn't unmute myself before. So we'll take up the questions from the chat box, and I'll come to my questions later. So we have another question in the chat box, which says, how much challenging it is to maintain Kazakhstan's or other nations' internal peace and security situated in Central Asia, when it is situated in such an area where Iran plays a huge role in state-sponsored terrorism, and also there are on the other side Golden Crescent, which is located and produces a lot of illicit drug traffic and so on. So what is your viewpoint on this?
Oh, thank you. I think it will be useful here to refer to Kazakhstan's official policy of multi-vector foreign policy. Kazakhstan being in the heart of Central Asia, so it's located between Russia to the north, the other Central Asian nations to the south, China to the east, Iran to the southwest. And what it means for Kazakhstan is that it has to do whatever it can to pursue a balanced foreign policy and to maintain as well as it can peaceful and constructive relations with all of its immediate neighbors, but also with other major regional and international actors. Kazakhstan works constructively with Turkey, with the European Union. Kazakhstan is one of a few nations which has enhanced partnership agreements with the European Union, and hopefully this agreement will result in a better rule of law in particular in Kazakhstan, in better investment protections and better respect for human rights in this country, because this agreement is about many various dimensions of cooperation between the European Union and Kazakhstan, and it should logically result in considerable improvements in those many areas. Of course, Kazakhstan is in economic and political alliances with the Russian Federation. Russia is a strategic partner for Kazakhstan, and Kazakhstan works together with Russia in a few economic projects. Of course, China is another important actor in Asia with which Kazakhstan maintains a constructive dialogue, and I hope this multi-vector foreign policy will continue, because given Kazakhstan's particular conditions, that is a huge territory and a relatively small population within that huge territory. So within these particular circumstances, the maintenance of balanced relations with various regional and international actors appears optimal.
Thank you, Dr. Sayapin. So coming to the next question, can you discuss what the fragmentation of international law means in the light of proliferation of courts and tribunals? As we know, in certain areas, separate legal norms and institutions have developed.
Thank you. This is an excellent question, just like all the others. Well, examples relative to the fragmentation of international law can be numerous, but since you're asking for one, let me give you one. Let's talk about human rights. Of course, human rights are understood somewhat differently in different regions of the world, and it's fine so. It is absolutely fine to have somewhat different perspectives on various aspects of international law. The main thing is that with some variations coming from different cultural, economic, and political backgrounds of states and societies, so states should comply with the core of international law, and then there will be more peace and security and order in the world. So the point I'm making here is that since regional perspectives on human rights are different, we have a universal human rights machinery at the United Nations. So we have the Human Rights Committee operating under the International Covenant on Civil and Political Rights. We have committees operating under the other treaty bodies, for example, under the Convention Against Torture, under the International Covenant on Economic, Social, and Cultural Rights, etc. So that is the universal human rights machinery. And there are also three human rights machineries in different regions of the world. There is a European Court of Human Rights in Strasbourg. There is an Inter-American Human Rights, a Court of Human Rights, and there is an African Court of Human and People's Rights. Those courts are technically independent from the UN human rights machinery. They are there to serve the needs and interests of the citizens in the respective regions, that is in Europe, in the Americas, and in Africa. And although those human rights courts, of course, monitor each other's practices, each other's case law, and the case law of the human rights, of the United Nations human rights mechanisms. So legally, they are independent of one another. Although they do follow and do monitor developments at the United Nations and in the other regions, so legally, strictly speaking, they are not obliged to follow the case law adopted by the other courts, because they are independent. They are distinct human rights organs. So, as a matter of practice, of course, they watch what the others are doing, and they try to produce a case law which is uniform and coherent with others, because if you wish, they want to represent the philosophy of human rights law as something which belongs to the entire human family. And of course, it is so. So with the relevant variations, human rights are a virtue which do belong to all humanity. However, the main point I want to make here is that in Asia, there is no human rights court. And this is probably an example where the problem of the fragmentation of international law, in particular of international human rights law, is very, very vivid. In the vast and diverse Asian region, there is no Asian human rights court. And probably there will be none in a near future. And probably there will never be one, because unlike the Americas or Europe or Africa, Asia is simply too big, too diverse, and too complicated in terms of legal traditions, in terms of political differences, in terms of languages. Think of how many different languages there are in Asia. It would simply be too difficult to arrange for a single human rights court in a region with so many different languages. And so to conclude on this topic, in the absence of a regional human rights court in Asia, of course, the universal human rights machinery at the United Nations is the option which the citizens of Asian states have if they cannot find redress for their alleged human rights violations in the domestic legal systems. So people in Europe, the Americas, or Africa can address their regional human rights courts before or instead of referring to the UN human rights machinery, because decision-making in regional human rights courts is quicker. Judges there have a better picture and understanding of regional concerns, and therefore it may be easier for them, well, in practical terms, to make decisions about circumstances which are around them, rather than for experts located elsewhere. In Asia, in the absence of such a regional human rights court, so citizens should seek redress within their domestic legal systems, or else if they would like to have international redress after exhausting domestic remedies, they should go to the United Nations human rights organs.
Thank you, Dr. Sayapin. So next question. What is the role and contribution of international courts in promoting peace?
It's a beautiful question, and the role of international courts is always important for the promotion of international peace to various extents. Because think about it. If we talk about a regional human rights court, then responding to a human rights violation contributes to the cause of peace at a micro level. If, however, a human rights court deals with extensive human rights violations, or, for example, in the aftermath of a situation of violence, or in the aftermath of an armed conflict, then, of course, there will be numerous similar human rights complaints addressed to the court. And as soon as a court addresses those massive human rights violations, it contributes at the same time to the pacification of the situation and to the settlement of a conflict which was there in the past and which was the ground for those human rights violations. Think of international criminal tribunals, such as the Nuremberg and Tokyo tribunals of the after the Second World War, or the international criminal tribunals for the former Yugoslavia or for Rwanda, or of hybrid tribunals which operated in various countries in the world after armed conflicts. All those criminal tribunals held liable individuals whose role was prominent in the commission of war crimes, crimes against humanity, the crime of genocide, and after such contexts of atrocity, it is very important to to punish the perpetrators, because it's about justice, and justice is often a precondition for the reestablishment of peace. If a crime of genocide was committed in context such as Rwanda or such as Cambodia, obviously people want justice, because without justice there is no peace. The survivors want to reestablish the honest names of their relatives. They want the perpetrators to pay for their crimes, and as soon as that happens, there is some hope for peace. Without justice, there will be no peace. And of course, the International Court of Justice in The Hague also deals with questions of war and peace. Think of the Nicaragua case, which became prominent in the history of international law. The ICJ dealt with a few border disputes between states, and border disputes are among the most typical issues that states have among them. And last but not least, the ICJ was on a few occasions prominent on discussing the questions of the use of force. One of the most recent examples is the case instituted by Ukraine against the Russian Federation in 2002, soon after the start of Russia's full-scale invasion of Ukraine, whereby Ukraine alleged that Russia had misused the notion of genocide as a pretext for the use of force against Ukraine. So to conclude with, international courts and tribunals play an increasingly important role in the maintenance of international peace and security in the framework of their respective mandates, and it should remain so.
Thank you, Dr. Sayapin. In context of the same question, could you please elaborate more, by giving the context of Central Asia, like the scenario in Central Asia?
Well, luckily enough, the answer to this question will be rather short. Luckily enough, Central Asia has not experienced any armed conflicts except the civil war in Tajikistan between 1992 and 1997, and therefore there's no case law dealing with the aftermath of armed conflicts or other situations of violence, because there have not been such situations warranting the involvement of international tribunals. On the other hand, I think it is regrettable that the Central Asian nations do not seem to be very keen on recognizing the jurisdiction of international courts and tribunals. For example, no Central Asian nation has recognized the obligatory jurisdiction of the International Court of Justice. As I also said, Tajikistan is the only state party to the Rome Statute of the International Criminal Court in the region. Kazakhstan could theoretically ratify the European Convention on Human Rights, but has not done so. Has not done that so far, and probably this will happen in the future. So there's virtually no international case law in Central Asia involving international courts and tribunals, because there have been no circumstances requiring that. But if in the future Central Asian states decide to become more open vis-a-vis international judicial organs, I think it will be a welcome development.
Thank you so much, Dr. Sayapin. So do you think, like facing these critical challenges, so do you think that states are also losing sovereignty in the age of globalization?
That's a difficult question, and I guess it's more a question for political scientists. I would say no, because sovereignty is a dynamic concept. Sovereignty is not static. Sovereignty does not mean that a state is absolutely supreme, absolutely independent, absolutely isolated from others. No, sovereignty is dynamic and functional. Making international law is a manifestation of sovereignty. So if states conclude treaties, they realize their sovereignty through that. And treaties are about rights and obligations. Of course, it's good for states to have rights under treaties, but rights do not exist without obligations. So when a state gets some rights, under a treaty. At the same time, it also gets duties. And this is another manifestation of sovereignty, to voluntarily accept duties so that the behavior of a state in the future becomes more predictable. Or another example, all states have a right to join international organizations and to leave international organizations if they want to. So on the one hand, it's good and useful for a state to be in international institutions because by joint efforts, it's easier to combat challenges and to find joint solutions for problems of concern to many states. On the other hand, international organizations mean there are, again, rules and obligations. It means that when a state joins an international organization, it has to obey the rules of the organization. Otherwise, there will be some measures of responsibility if a state violates the rules of the organization. So sovereignty is in this way limited by membership in the organization. So a state voluntarily agrees to accept those limits on its sovereignty. A state voluntarily agrees to obey the rules of the organization for the sake of greater benefits which membership promises. So in that sense, I would say that the concept of sovereignty is still there. Simply, its content and understanding have evolved. Sovereignty is not anymore something absolute, something unchangeable. By contrast, the concept of sovereignty has become functional, dynamic, and in that way better responsive to modern realities.
Thank you so much, Dr. Sayapin. In addition to the same question, also I want to add one more part to this question, that considering the fact that all states jealously guard their sovereignty, so is it possible to have effective compliance with international law?
International law is an interesting thing. It, as an eminent American international lawyer, Louis Henkin, once said, most states comply with most of international law most of the time. And I think it's a good way to think and speak of international law. So, indeed, although international law does not have an enforcement machinery in the same way as domestic legal systems do, like there is no world parliament making international laws, there is no world police that would catch the violators of international law and put them after a judgment by an international court with compulsory jurisdiction into an international prison. So international law does not work in the same way as domestic legal systems do, but still it works. Still, and it works without us even noticing it, or without us even thinking about it most of the time. Agree that we tend to think about international law when it's violated, when there are gross human rights violations, when there is a trade war, when there is an armed conflict, when there is a global problem such as the pandemic. Then if something like that happens, then we understand that something has gone wrong in the international system, and most of the time it will be related to some violation of international law. But as long as everything works, we do not think of international law, we do not notice it, because if international trade works fine, if international transportation works fine, if human rights are complied with, we take it for granted. But if you think about it, it all means that international law works, which means in turn that states give up a part of their sovereignty by making rules of international law, but they do that for a greater benefit. And it ultimately means that international law is a great thing to have.
Indeed, indeed. And thank you so much for your answer. I think it is an interesting area. I agree, sovereignty is a dynamic concept. And drawing from your answer, let me ask, we hear a lot about regional cooperation and integration in the Central Asian region among the five republics. So, what role do you think international law plays in this regard? Can closer cooperation to regionalism happen, like, say, the development of a regional organization?
I do hope that there will be further successes in Central Asia's regional integration. As I said before, the Central Asian states are already members in a few regional organizations, and there are prospects for a Central Asian Union. This is just an idea for the time being. Politicians talk about it sometimes here and there, but there's no institutional mechanism in place yet. I hope this union will materialize sometime in the future because it will be beneficial for all Central Asian states. They're all very different with different sizes, resources, populations. And if a Central Asian Union could help put together, for instance, the vast resources of Kazakhstan, the region's biggest labor force in Uzbekistan, the water reserves of Kyrgyzstan and Tajikistan, uh, and thus bring together in a smart and coherent way the natural, human, economic, intellectual, and other resources of all five nations of the region. This would be beneficial to everyone. And of course, if this happened, it would happen on the basis of international law, because there would be treaties concerning various aspects of Central Asian integration. There would be an institutional framework. I hope it is feasible, and I hope it will happen sometime in, if not in a short-term perspective, then probably at least in a mid-term perspective.
Thank you so much for your answer. So just one last question. So at the Tillotoma Foundation, we are very gender inclusive. So I want to ask one thing, that have any women been appointed to the International Law Commission? And if yes, what is the role of women in international law decision making?
This is a beautiful question, and I wish women could play increasingly important roles in international institutions. So unfortunately, no woman has been appointed as a Secretary General of the United Nations so far. There were female candidates for that post, but the post has so far been occupied only by men. There have been a few ladies on the International Court of Justice, but their number was relatively insignificant, and I hope there will be more female judges on the world's most important international court. Currently, there are a few ladies on the International Law Commission. I'm pleased to work and to cooperate in a few projects, for example, with Dr. Niloufer Oral, who is a member at the International Law Commission and director at the Center for International Law at the National University of Singapore. She and her colleague, Dr. Patricia Galvao Teles, who is also a member of the International Law Commission, they are running annual online academies on international law for students predominantly from Asia, but also from other parts of the world. And I was pleased and honored to lecture already twice at such annual academies. So these the examples that Niloufer and Patricia are showing are truly inspiring. These examples prove that 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 the participation of ladies in various organs of the United Nations must be increasingly more prominent. That gender inequality, unfortunately, still persists, including in various international institutions, and more should be done to make ladies more representative in those expert and decision-making formats. And I am personally happy to learn from Niloufer, from Patricia, from my female professors at various universities where I have studied, and I am eternally grateful for them, to them, for the knowledge and experience which they gave to me.
Thank you so much, Dr. Sergey Sayapin, for the answer. I think we are done with the questions, and it was an insightful it was an insightful discussion today, and I'm very sure that the attendees also had a great learning experience. Let me thank you for being here and delivering an excellent talk on international law and the regional context in Central Asia. We hope to see you again. Thank you so much.